Hi, welcome back. So far we've discussed the world's great legal systems, and now we go to an aspect of the law which is in many ways just as important as the substance of the law, and that is the resolution of disputes. How is it that we resolve disputes, especially in the international context? So we know that the law is meant to regulate relationships. That's what the law does. And one of the ways that the law regulates relationships is to provide a framework for the resolution of disputes. Now, there are different methods for resolving disputes. There are public means and there are private means. And in the international context, parties will usually choose private resolution methods for many of the reasons that we will talk about in here. And so in this lecture, we're going to focus on private resolution methods in which the parties agree to resolve the matters between themselves and not involving any governmental agency or court. So in this lecture, we're going to look at the private means of resolving disputes. Now, we start with this question: how should businesses handle disputes? What is the best way to deal with disputes? And of course, the best means of resolving disputes is to avoid them. In the second half of this class, we're going to be looking at contract formation. And one of the key things you want to do in contract formation is to anticipate potential disputes and address them within the body of the contract. Now, litigation in court is the primary means of resolving disputes. However, privatized methods provide an alternative means of resolving disputes. And there are many particular areas of concern with international disputes. Now, there are two issues that will always come up with any international business dispute. And the first is choice of forum. Where is the case going to be heard? Is it going to be heard in the country of the seller? Is it going to be heard in the country of the buyer? Is it going to be heard in a third and neutral country? This is one of the factors that are present in any dispute. This question must be asked and answered in any international dispute. And the second is choice of law. What law will apply to the dispute? If I am a business in Kansas and I'm doing business with a business in London and we get into a dispute, will it be American law? Will it be English law? Will it be international law? These are factors that we can anticipate in our contracts and set them out. So we can anticipate this problem of where's the case going to be heard, and we can decide that. And we can also look at what law will apply to the dispute. And again, courts will recognize our choices, but if we don't make those choices in the contract, we're going to have to find the answers somewhere else. Now, there are three primary ways of resolving disputes. The first is negotiation. And we'll talk a little bit more about negotiation. But again, essentially, negotiation involves resolving a dispute between the parties themselves, not involving any third party. The second is what we call alternative dispute resolution or alternate dispute resolution. And it's an alternate to litigation, which is to say litigation being handling a dispute in court, whereas in an alternate dispute resolution, we handle the dispute through privatized means.